Well, it appears the U.S. Supreme Court can't seem to keep its abortion decisions from the public before they want them to be seen by the public. In maternal terms, once again, their water broke before viability. And it seems the court is ready to allow emergency abortions in Idaho when a pregnant woman's health is at risk, not just her life. The headline from Bloomberg News this morning said the court was, quote, poised to allow because, well, this morning someone posted that SCOTUS opinion by mistake on that website. The draft was quickly taken down, but not before Bloomberg grabbed it. Afterwards, the Supreme Court admitted someone did jump the gun. But here is what we know and how we got here and where it appears we are now. In March of 2020, Idaho passed its trigger law. June of 2022, the Supreme Court overturned Roe v. Wade with the Dobbs decision, returning abortion rights to the states and triggering Idaho's ban. August 2nd of 2022, weeks before Idaho's ban would go into effect officially, the Department of Justice filed a lawsuit against Idaho and its legislature saying the exception in the law which allows abortion to save the life of the mother was too narrow and violates the Federal Emergency Treatment and Labor Act, or EMTALA, which specifies health of the individual seeking emergency care. Idaho's law did go into effect on August 24th of 2022. However, the U.S. District Court of Idaho granted a preliminary injunction, putting the law on pause while it works its way through the courts. That decision was appealed to the Ninth Circuit Court of Appeals, who stopped the injunction. Then they reinstated it a month later. Idaho appealed that decision to the U.S. Supreme Court, who agreed to hear the case in January, and in doing so, lifted the injunction, allowing Idaho's law to go into effect for the very first time. Okay, so SCOTUS heard oral arguments in April, and because of that, the justices are apparently ready to reveal, well, they shouldn't have. If this posted opinion stands, it shows they simply dismissed the case, saying they improvidently granted the writ of certiorari, which is legalese for they shouldn't have gotten involved in the case so quickly. In other words, they could be punting. I've read the draft opinion on this, by the way, and if it is real, and it stands, in a 6-3 decision, dismissing the case will revert it back to the Ninth Circuit, that is, the Ninth Circuit Court of Appeals ruling, which will reinstate the injunction while the lawsuit is decided, meaning, as Justice Elena Kagan wrote, it will prevent Idaho from enforcing its abortion ban when the termination of a pregnancy is needed to prevent serious harms to a woman's health. Justice Amy Coney Barrett agreed, saying this case should be dismissed because it has substantially shifted since the lawsuit was filed 2 years ago. Remember, it's changed a couple of times since that lawsuit was filed. She wrote, adding a few more exceptions and removing the burden of proof from the doctor. The legal proceedings, they haven't had a chance to catch up with that, she said. Again, this is not an official opinion from the Supreme Court yet, but rather, it's one that was mistakenly posted way too soon, which is why Idaho's parties involved in this case, that'd be Attorney General Raul Labrador, Speaker of the House Mike Moyle, even the doctors we spoke with about this last week, they all want to wait to comment until it is official. Important to note, this will do little to change Idaho's abortion ban, just so you know. As Justice Barrett wrote in this decision, when it actually gets handed down, possibly as soon as tomorrow, even with the injunction in place, Idaho's ability to enforce its law remains almost entirely intact.